And welcome to the first episode of Season 2 of my vlog, Personal Injury Lawyer Tips. My name is Leroy Rudder. I'm a personal injury lawyer specializing in catastrophic impairment law. I'm also a published author of the LexisNexis Inc. book called Catastrophic Impairment Law in Canada, a director at Head Injury Rehabilitation Ontario, a co-chair of the Law Society of Ontario's annual solo and small law firm conference, and the founder and owner of my law firm, Rudder Law Group. In this vlog, I'll be discussing the criteria that you must satisfy in order to obtain a catastrophic impairment designation for a mental and behavioral disorder you sustained as a result of a motor vehicle accident in Ontario. But first, I'd like to explain to you what it means to get a catastrophic impairment designation. A catastrophic impairment designation places you, an auto accident victim, in the highest level of impairment category available under automobile insurance regulations. While not a benefit itself, a catastrophic impairment designation is the gateway to access enhanced benefits, where your policy limits increase from $3,500 or $65,000 to $1 million. All other impairments fall under the non-catastrophic and minor injury categories. If you want to learn more about the companion accident benefits claim and kickstarting the accident benefits application process, then please watch the first episode of Season 1 of my vlog entitled How to Get Your Accident Benefits Application Started. So what constitutes a catastrophic impairment is defined in Ontario's Statutory Accident Benefits Schedule, which is also known as SABS for short. It's a regulation issued under Ontario's Insurance Act. It's included in every motor vehicle accident policy in Ontario. It is a mandatory form of no-fault insurance that provides certain accident benefits to anyone injured in an auto accident, regardless of who is at fault. Since the 1990s, the SABS had undergone significant changes. Section 3.1 was added to the SABS, which provided a tightening of the criteria for determination of catastrophic impairment. The most recent and profoundly significant reform to Ontario's no-fault insurance took effect on June 1st, 2016. The 2016 amendments to the SABS introduced a stricter definition of catastrophic impairment. Section 3.1 provides the criteria for determining more than one kind of catastrophic impairment, such as, for example, paraplegia, tetraplegia, a traumatic brain injury, a severe impairment of ambulatory mobility or the use of an arm, or amputation, etc. However, in this vlog, I'll discuss the criteria for determining if an insured person's mental and behavioral disorder sustained in a motor vehicle accident on or after June 1st, 2016, is a catastrophic impairment as defined in the SABS. It's easier to understand legal criteria when it's being applied to the facts of a case. So I'll discuss a recent License Appeal Tribunal decision. The name of the case is Simmons and Bel Air Direct Insurance Company. This case focuses on the catastrophic criteria regarding mental and behavioral disorders, which is set out in Section 3.11, Paragraph 8 of the SABS. So in this case, the applicant, Ms. Sarah Simmons, was involved in a motor vehicle accident on February 15, 2018. She was traveling on a provincial highway at approximately 70 kilometers per hour and crashed into a tractor pulling a car out of the ditch on a foggy day. She sustained a concussion and a fracture of her tibia that required surgery. After the MVA, she was diagnosed with several mental disorders in accordance with the Diagnostic and Statistical Manual of Mental Disorders, 5th edition, or the DSM-5 for short. She exhausted the policy limits of $65,000 in medical, rehabilitation, and attendant care benefits, which was available to her in a non-catastrophic impairment category. She alleged that she suffered from a catastrophic impairment due to a mental or behavioral disorder pursuant to Section 3.11, Paragraph 8 of the SABS, which would increase her policy limits from $65,000 to $1 million. The primary issue in this case was as follows. Has the applicant, Ms. Sarah Simmons, sustained a catastrophic impairment within the meaning of Section 3.11, Paragraph 8 of the SABS? At the root of this issue is the causation test, which asks whether the applicant, Ms. Sarah Simmons, would not be catastrophically impaired within the meaning of Section 3.11, Paragraph 8 of the SABS, but for the accident. So has Ms. Simmons sustained a catastrophic impairment? Well, in order for Ms. Simmons to prove she sustained a catastrophic impairment in accordance with Section 3.11, Paragraph 8 of the SABS, she must establish that she sustained a mental or behavioral disorder resulting in either 1, a Class 4 marked impairment in at least 3 or more areas of function that precludes useful functioning, or 2, a Class 5 extreme impairment in at least 1 or more areas of function that precludes useful functioning. The impairment is rated in accordance with Chapter 14 of the 4th edition of the American Medical Association Guides, or the AMA Guides 4 for short. So what is the AMA Guides? Well, it provides physicians with a reliable, repeatable measurement framework for permanent impairment in patients who have suffered an injury resulting in long-term reduction of body function. Once a patient has reached maximum medical improvement, physicians use the AMA Guides to assess a patient's impairment and document findings. While assessing the severity of an individual's mental impairment, and considering the levels of independence, appropriateness, and effectiveness of an individual's activities, a physician must focus on the effect of the mental impairment on the following 4 areas of function. 1, limitations in activities of daily living. 2, social functioning. 3, concentration, persistence, and pace. And 4, deterioration or decompensation in work or work-like settings, which is also referred to as adaptation. So the first area is the effect on an individual's capacity to engage in activities of daily living, which includes but not limited to self-care, personal hygiene, communication, ambulation, travel, sexual function, sleep, and social and recreational activities. A physician you retain is not merely identifying all of the individual's activities of daily living that he or she has restrictions. The physician you retain must also evaluate and document the overall degree of the whole restriction and combination of restrictions, as the whole impact of all restrictions is greater than the sum of the separate restrictions. For example, an individual may still have a marked mental impairment if he or she was not restricted in self-care activities such as personal hygiene and grooming, but suffered a paralyzing fear of leaving her family home to go to school. The second area is the effect on an individual's capacity of social functioning and interacting with other people, which includes the ability to get along with others, such as family members, friends, and members of the public. Some indicators of impaired social functioning include the inability to initiate social contact with others, communicate clearly, and interact and actively participate in group activities and cooperative behavior, and to show consideration for others, awareness of others' sensitivities, and social maturity. Again, the physician you retain must evaluate and document the overall degree of the whole interference or combination of interferences that the mental impairment has with the capacity of an individual to interact with other people. In the Simmons and Belair direct case, one of the most dramatic changes in the applicant's social functioning after the accident was her emotional volatility, as she became short-tempered, aggressive, and profane. The adjudicator heavily relied upon the testimony of the applicant's mother, who recounted past examples of her emotional volatility. The third area is the effect on the task completion capacity of an individual to sustain focused attention for a long enough period of time in activities to make them meaningful, which requires concentration, persistence, and pacing. In this third area, Knowing the history of the individual's ability to sustain focused attention on tasks from both medical and non-medical sources is important in order to establish a baseline to adequately compare the results from the current clinical evaluations and psychological testing. It's also important for the assessing physician you retain to consider the context as well. For example, an individual may be able to sustain focused attention for a period of time in a controlled environment, such as a physician's office, or a safe environment, such as his or her home, while surrounded by the loving members of the immediate family. However, if the individual transitions to an external setting such as a school or a work environment where demands are high, pressure is prevalent, the frequency in errors, the time it takes to complete tasks, and the dependency on other people for assistance may all increase due to the effect the mental impairment has on his or her capacity to manage stress. The fourth area is the effect on the individual's deterioration or decompensation in work or work-like settings, or the incapacity to adapt to stressful circumstances. When an individual with a mental impairment is placed in a situation where he or she faces stressful circumstances in the workplace, the individual tends to withdraw from the situation, or decompensate and have difficulty maintaining activities of daily living, continuing social relationships, and completing tasks. While assessing the severity of mental impairment, the physician you retain must focus on which of these four capacities have been retained. 1. Understanding and memory, in regards to the capacity to remember procedures related to work. 2. Sustained concentration and persistence, in regards to the capacity to maintain attention for extended periods of time to complete tasks at work. 3. Social interaction, in regards to the capacity to interact with other people and coworkers. And 4. Adaptation, in regards to the capacity to adjust to changes in work or work-like settings. In the Simmons and Belair Direct case, the most dramatic illustration of decompensation came from the applicant's occupational therapy report. The occupational therapist did an in-home assessment, which consisted of interviewing the applicant and her mother, having the applicant complete questionnaires, and testing her basic physical abilities. He incorporated a situational component to the assessment, which tested the applicant's functional capacities by having her complete everyday tasks. He brought her to a grocery store and provided her with a list of items. As such, a community outing is an instructive test of a person's real-life function because there are more sources of stimulation and stress than at home. The applicant demonstrated such significant stress while at the grocery store that the test had to be terminated, which was more compelling and supportive evidence of her incapacity to adapt to stressful circumstances. So while assessing the severity of an individual's mental impairment, a physician must also focus on the severity level of the mental impairment on the aforementioned four areas of function by classifying the impairment level in categories. So there are 5 categories or classes of impairment, which are as follows. Class 1, or no impairment, where no mental impairment is noted. Class 2, or mild impairment, where the mental impairment levels are compatible with most useful functioning. Class 3, or moderate impairment, where mental impairment levels are compatible with some, but not all, useful functioning. Class 4, or marked impairment, where mental impairment levels significantly impede useful functioning. And Class 5, or extreme impairment, where mental impairment levels preclude useful functioning. Again, remember, in order to prove that you sustain a catastrophic impairment in accordance with Section 3.11, Paragraph 8 of the SABS, you must establish that you sustain a mental or behavioral disorder resulting either a Class 4 marked impairment in 3 or more areas of function that precludes useful functioning, or a Class 5 extreme impairment in 1 or more areas of function that precludes useful functioning. In Simmons and Belair Direct, the applicant, Ms. Simmons, claimed that she suffered from a Class 4 marked impairment in activities of daily living, social functioning, and adaptation. She didn't claim that she suffered from a Class 5 extreme impairment in any area of function. The respondent, Bel Air Direct, claimed that Ms. Simmons suffered from a Class 4 marked impairment only in activities of daily living and a Class 3 moderate impairment in the other 3 areas of function. It also argued that the accident did not cause the applicant's impairments. So let's take a look at the experts that were relied upon in this case. The applicant relied on 3 experts, a psychiatrist and a neuropsychiatrist, and another psychiatrist, who assessed the severity of Ms. Simmons' impairments in the 4 areas of function, as well as an occupational therapist who collected information about her functional abilities, but did not assess her level of impairment. The respondent relied on 2 experts, a psychologist, not a psychiatrist, who assessed the severity of the applicant's impairments in the 4 areas of function, as well as an occupational therapist, who again just collected information about the applicant's functional abilities, but did not assess her level of impairment. Sometimes you have to be careful if using a psychologist in cases where there is a need to understand the interaction between a person's psychological symptoms and his or her pain and concussion symptoms in order to understand the full scope of his or her impairment. Since a psychologist is not a medical doctor, there is a risk that his or her analysis may exclusively focus on impairments caused by depression and anxiety, where an understanding of the full scope of the impairment is needed. In deciding whether or not Ms. Simmons sustained a catastrophic impairment due to a mental or behavioral disorder, the adjudicator relied on the 3-step approach set out by the Court of Appeal for Ontario in the case entitled Pastor and Aviva. The 3-step approach asked the following questions. Question number 1, did the accident cause the applicant to suffer a mental or behavioral disorder? Question number 2, if it did, what is the impact of the mental or behavioral disorder on the applicant's life? And question number 3, in view of the impact, what is the level of impairments? Given the overlap between steps 2 and 3, the adjudicator in this case addressed them together. In regards to the first branch of the Pastor and Aviva test, did the accident cause the applicant to suffer a mental or behavioral disorder? The adjudicator found that the applicant suffered from mental or behavioral disorders due to the accident. Reason number 1 had to do with her pre-accident diagnoses. Before the accident, Ms. Simmons was not diagnosed with any psychological disorders. Reason number 2 had to do with her post-accident diagnoses. After the accident, various treating practitioners and retained experts and assessors diagnosed Ms. Simmons with disorders listed in the Diagnostic and Statistical Manual of Mental Disorders, 5th edition. Reason number 3 had to do with the respondent's concessions. The respondent conceded that the accident was one of the contributing factors to the applicant's impairments due to a mental or behavioral disorder. Lastly, all the treatment providers and assessors were of the view that the applicant suffered from at least one mental or behavioral disorder due to the accident. In finding that the applicant satisfied the first branch of the Pastor and Aviva test, the adjudicator also expounded upon the applicable test for causation, which is whether the applicant would not be catastrophically impaired but for the accident. In response to Bel Air Direct's argument that the accident was not the sole cause of the applicant's impairments, the adjudicator noted that the but-for test for causation doesn't require the accident to be the sole cause of the applicant's impairments. It only requires that the accident must be a necessary cause of the applicant's impairments, but not be sufficient in itself to cause those impairments. In regards to the second and third branch of the Pastor Aviva test, what is the level of impairment? The adjudicator found that the applicant, Ms. Sarah Simmons, suffered from a Class 4 marked impairment in 3 areas of function, namely activities of daily living, social functioning, and adaptation. In arriving at this finding, the adjudicator heavily relied on the following evidence. 1. The testimony from the applicant and her mother, who both described how her mental health issues affected her. 2. The testimony from her family doctor, who demonstrated clearly how he knew the applicant well and had a detailed understanding of her health issues and their implications. 3. The occupational therapy reports, which described her functional abilities and the limitations caused by her health conditions. And 4. The testimony from the assessing physicians, psychiatrists and neuropsychiatrists, who drew from the occupational therapy reports and obtained further information from the applicant's medical records and through their own clinical evaluations. Even though the adjudicator took the expert evidence of assessors into account, he ultimately determined the applicant's levels of impairment himself by applying the evidence to the criteria in the AMA guides. This is important to keep in mind because the determination of whether the applicant sustained a catastrophic impairment is a legal question and not a medical one. The adjudicator did not accept the medical opinion of the respondent's expert, the psychologist, because he gave greater weight to his observations of the applicant than to the documents he reviewed, most notably the CNRs of the family doctor. The adjudicator rejected the medical opinion of the respondent's expert for 2 reasons. 1, his assessment or clinical evaluation was a snapshot in time that captured a peak in the applicant's level of function and optimism. As such, it did not accurately reflect the severity of the applicant's impairments most of the time. He did not properly weigh the additional CNRs he received, which supported the severity of the applicant's impairments. And 2, he only observed the applicant in a controlled environment. The assessment or clinical evaluation was held in his office and lasted 3 hours. However, the AMA guides cautions us that a single examination may not adequately describe a person's ability to function in a sustained way, and that it is necessary to review information pertaining to the individual's functioning at times of increased stress. This is why it's so important for a psychiatrist or psychologist to rely on an occupational therapist report, where an OT assesses the individual at his or her home, interviews people close to the individual, has the individual complete a questionnaire, tests the individual's basic physical abilities, and incorporates a situational component of the assessment via a community outing, which tests the individual's real-life functional capacities outside of the home, where there are more sources of stimulation and stress. Since the respondent's expert gave primacy to his own observations of the applicant, he did not give sufficient weight to the evidence documenting her ability to handle stressful, real-world situations. The biggest takeaway from this recent LAT decision is that the physician you retain, ideally a psychiatrist or a psychologist, must reconcile his or her clinical examination, inclusive of standardized psychological tests, with non-medical sources such as listening to the individual's description of his or her limitations and restrictions and assigning the appropriate weight to the self-reporting, relying on non-medical information via interviews of close family and friends who witnessed the negative effect of the individual's psychiatric impairment on his or her ability to function. The physician must also reconcile his or her clinical examination with medical sources, such as the CNRs from other treating physicians, psychiatrists, psychologists, family doctor, etc., that covers an adequate period of time prior to the date of the clinical examination, as well as an occupational therapist report. The occupational therapist report must incorporate a situational component of the assessment via a community outing that tests the individual's real-life functional capacities outside of the home, where there are more sources of stimulation and stress, and detailed descriptions and recorded observations of the individual's activities of daily living, social functioning, concentration, persistence, and pace, and the ability to tolerate increased mental demands, i.e. stress. Lastly, don't forget that subsection 3.13 of the SABS is applicable. The section I've been discussing in this vlog, section 3.11 paragraph 8 of the SABS, does not apply if you, an insured person, sustained an impairment as a result of the accident unless 2 years have elapsed since the accident, or a physician states in writing that your impairment is unlikely to improve to less than a class 4 marked impairment in 3 or more areas of function that precludes useful functioning due to a mental or behavioral disorder. So, if you're trying to obtain a catastrophic impairment designation for a mental and behavioral disorder within 2 years of your accident, then the physician you retain must state in writing that your impairment in at least 3 of the 4 areas of functioning is unlikely to change substantially and by more than 3% in the next year to less than a class 4 marked impairment. The reason why I say 3% is because the AMA Guides defines permanent impairment as an impairment that is unlikely to change substantially and by more than 3% in the next year with or without medication, which was confirmed in a recent 2020 LAT decision called Applicant and RSA Insurance. I hope you found this information valuable. If you want more information, then please read my blog called What is a Catastrophic Impairment? In my blog, I take a deep dive into the tightening of the criteria for determination of catastrophic impairment with the addition of section 3.1 of the SABS and the stricter definition of the determination of a catastrophic impairment, which came with the June 1st, 2016 amendments to the SABS. I also provide links to other blogs such as how does a guideline impact the determination of a catastrophic impairment, catastrophic impairment, pediatric traumatic brain injuries, an amputation and permanent loss, spinal cord independence measure, version 3, which provide additional information that you'll find helpful. My website is your one-stop source for answers to all of your legal questions concerning tort law, personal injury law, and catastrophic impairment law. If you want to book a free consultation with me, then please visit my webpage at RudderLawGroup.ca and click on the free consultation button at the top of the page. Let us be your rudder that steers your legal ship in the right direction. Please subscribe to my YouTube channel and click the like button if you found the content valuable. There you'll also find other vlogs of valuable content on tort law, personal injury law, and catastrophic impairment law. Thank you, and I'll see you soon in episode 2 of season 2 of Personal Injury Lawyer Tips, where I'll bring you more useful legal information.